Good afternoon, everybody, and welcome to Rhode Island Soapbox. This afternoon we have a wonderful program going. The subject of the program is, as you may have seen on the screen, the case for gay marriage in Rhode Island and how we can work for justice. So with us today, Kate Bohl, who is a professor at Stetson University Law School in Florida, Jen Seinfeld, who is one of the head people in marriage equality.
I've been promoted since the last time I was on. I'm the director now.
Director of Marriage Equality Rhode Island. And Brad Pelletier, who is about to graduate from Roger Williams Law School and expects to practice law in Rhode Island. So what we're going to talk about today is Kate's research that she's been doing on the history of Rhode Island law and the Rhode Island Constitution. Yes. Now, I'm not a lawyer, so you correct me if I say something wrong, but as to how the history, historically, the Rhode Island legal world is set to accept or develop or not accept the whole idea of gay marriage. So that's where we go, and I'll let you, you've just written or about to be published an article on
Yes, my
that.
article will appear as the lead article in the next volume of the Roger Williams Law Review. Yep. And my particular focus is on the Goodrich opinion and how Rhode Island case law, if you transplant the Goodrich theories into Rhode Island, how Rhode Island is already poised in a number of good decisions to recognize gay marriage. Okay. And I was happy to be on a panel with these two because that's my particular area, not the politics of gay marriage in Rhode Island or the political process involved, and not even particularly the Rhode Island Constitution itself. I really looked at the Goodrich opinion, the theories, and the case law that...
Tell me, as a layperson, Goodrich opinion, when and where?
Goodrich opinion is the so-called Massachusetts gay marriage decision. Right. And I've heard it referred to as the imperious work of a handful of sitting Massachusetts judges. And I think if people actually knew what the opinion said, they would object to such a description themselves because it's a thoughtful, sensitive opinion that really takes into account the concerns that all Rhode Islanders have had and that are reflected in a lot of Rhode Island laws over the past few decades. So can I give a little nutshell of what the opinion does and how it works?
I think that would be helpful, don't you guys? And please ask questions because I'm not a lawyer.
Judy, you ask questions because we do this all the time.
Okay. I'll try to be Joe Public here.
All right.
Okay, the Goodrich opinion itself begins with a description of the plaintiffs, the couples, the same-sex couples that brought suit. And it describes them not only in terms of their names and their ages, but in terms of their family life. And it does so in great detail. It talks about their children, their elderly parents, their children's successes, their hopes and aspirations for themselves and their children. And the first time you read that, you think, well, that's very nice, but you don't realize where the court is going until the next stage in the opinion, when the court talks about the nature of marriage itself. Marriage is such a key to many of the rights and protections of society that we take for granted. Particularly, says the court, marriage is a source of protection, stability, and comfort for children. Children who have married parents do better in a whole range of situations, from economics to schools. They have safety nets that children of unmarried parents don't have.
So this was the Massachusetts court decision.
Right. This is the Supreme Judicial Court that has been given such short shrift and has been condemned so cavalierly. It actually focuses a good bit in the beginning on how marriage helps children. And it talks about how laws have been enacted in Massachusetts that protect and help children. The most obvious example, we no longer refer to children born out of wedlock as bastards. There is a desire to have all children have an equal start in life. We don't want to condemn some children by accidents of their birth. So the court explains that you really can't compensate a child who doesn't have married parents. You can't restore those rights in any other way. You can do it piecemeal through contracts of different kinds, but you can't give the child that whole package of protection, social equivalence, and even the intangibles of respect of classmates. It's just not possible to do that. And having set the stage for the analysis by focusing on children.
And by seeing that children of unmarried parents are stigmatized in some way.
Right.
Bullied or whatever. Okay.
Right. Then the court goes on. Then the court goes on to talk about the many ways in which we encourage people to have children, not necessarily in a traditional husband and wife relationship. We want people to adopt children. And we make adopted children as equal as we possibly can to natural children. So childbirth has really been separated by the consensus of the people of Massachusetts and Rhode Island from marriage.
Okay.
So that's sort of the beginning of
that was the beginning.
Yes,
all right.
That's the beginning of the argument.
All right. Now, excuse me. Take it on through where we are in Rhode Island and how the Rhode Island laws.
Okay. Let me just to give one more little look into the opinion itself, because the U.S. Supreme Court has held that intimate, consensual, adult sexual relationships are entitled to privacy, period. And the court has said we as a society, we don't want to be in the business of evaluating those intimate, private, consensual adult relationships. We shouldn't be. They're protected by that same pattern of privacy that all intimate, consensual adult requirements are protected by.
Sometimes not so much as others.
Right, but
recall a
at
few
least the
incidents
law.
in Texas, but this is Rhode Island, okay.
Right.
And we are talking about what's just, and we're trying to
And it's
get
also
there.
the law in Rhode Island that one cannot, in light of the Lawrence v. Texas decision that eventually worked its way up to the Supreme Court, one cannot actually penalize people who are adult, consensual, practicing homosexuals. So that was another piece of the puzzle for the Massachusetts Supreme Judicial Court. Marriage benefits children, private relationships are entitled to privacy under the law, and that if we put these ingredients together, it's not rational for the state to disadvantage same-sex couples and their children.